Debate, the Honourable Member for Edmonton, St. Albert.
Thank you very much, Mr. Speaker. I am honoured and humbled to be able to participate in this debate concerning Bill C31, an important piece of substantive criminal legislation with procedural paragraphs as well that seeks to modernize criminal procedure and make the justice system more efficient and also more effective. Mr. Speaker, crime in Canada is constantly evolving, and it is crucial that our criminal justice system evolve with it. The amendments proposed in Bill C31 are the latest steps in our continuing commitment to tackling crime and ensuring the safety and security of our communities. Mr. Speaker, this bill contains some 40 amendments developed in consultation with our provincial and territorial partners and other stakeholders in the criminal justice system who have helped us identify processes in the need of updating and the issues that require attention to keep the criminal law modern and up to date with more and more sophisticated criminals. Given the limited resources available in the criminal justice system, it has become abundantly clear that we need to find better and more efficient and effective ways to respond to crime and make better use of those sometimes scarce resources. Mr. Speaker, I would now like to take the opportunity to highlight some of the amendments that the government is proposing in Bill C31. Firstly, with respect to agents. With respect to the use of agents or non-lawyers, this bill will allow the provinces to further monitor the quality of representation by agents of defendants charged with summary conviction offences. Mr. Speaker, currently agents who are not lawyers may appear and may examine and even cross-examine witnesses on behalf of defendants charged with summary conviction offences, those offences that carry a maximum term of imprisonment of 6 months or less. For summary offences carrying a maximum term of imprisonment of more than 6 months, agents may represent defendants only if they are authorized to do so in accordance with a provincially or territorially approved program. Mr. Speaker, agents perform a valuable function, particularly in northern and remote areas of Canada, where Native court workers acting as agents for defendants frequently provide assistance to defendants. We must keep in mind, however, Mr. Speaker, that serious consequences can arise even from a criminal conviction from a summary conviction offence, and in many criminal cases involve a significant degree of complexity. In order to further promote adequate representation for defendants who choose to be represented by non-lawyers, changes to the rules regarding agent representation will allow the provinces and the territories to set criteria and approve programs for the full panoply of summary conviction offences. Amendments to the Criminal Code, Mr. Speaker, will allow jurisdictions to set criteria or approve programs which will serve as preconditions to representing defendants charged with summary offences that carry a maximum jail term of 6 months or less. However, in jurisdictions where no programs have been approved and no criteria have been set for this category of offences, agents will still be authorized to represent defendants, as is the case currently. The situation will also remain unchanged with respect to summary offences that carry a maximum jail term of more than 6 months. It will continue to be open to jurisdictions to approve programs or set criteria that serve as preconditions to representing defendants charged with these more serious offences. However, no agent is authorized to represent defendants in jurisdictions where no programs have been approved or criteria have been set. Finally, for any summary offence, it will always be open to agents to appear on behalf of defendants to request an adjournment in summary conviction proceedings. Secondly, the bill deals with expert witness evidence. Amendments in the area proposed in this bill, Mr. Speaker, are intended to improve the current regime to ensure that all parties have the opportunity to adequately respond to what is frequently becoming complex and highly technical evidence. When expert evidence is to be presented at trial, this bill creates new remedies designed to encourage parties to comply with the regime's notice requirements, as well as better address situations of non-compliance. Proposed new provisions also contain a list of factors which the court must consider in deciding whether to grant adjournments. Where the court refuses to grant an adjournment or reduce its duration, proposed amendments will require the court to provide reasons. The bill thus sends a clear message as to the numerous considerations and significant challenges associated with properly responding to expert evidence. Thirdly, the hybridization of certain non-violent criminal code offences. Mr. Mr. Speaker, hybridization of an offence is the legislative process of converting a straight summary offence or a straight indictable offence into a hybrid offence. This process affords the Crown the flexibility to make an election, to elect whether to prosecute an offence by way of summary conviction procedure or by indictment. Proceeding by summary conviction offers an expedited trial process and a lower penalty range, whereas prosecuting by indictment involves the possibility of holding a preliminary inquiry as well as a jury trial and offers a higher penalty range. Mr. Speaker, the proposed amendments will allow the Crown to select the most appropriate procedure in light of all of the circumstances surrounding the case for 6 non-violent and specified offences, 3 of which are currently straight indictable offences and 3 are straight summary conviction offences. Hybridization offers a means of ensuring that we make the best use of our court's limited resources and the more elaborate proceedings involving preliminary inquiries and make jury trials reserving for only the most serious offences. The hybridization of current straight indictable offences also benefits the accused as it allows the Crown, when appropriate, to proceed summarily in a more expeditious trial process and therefore a lower penalty range. Next, leaving the jurisdiction while under an order not to. Individuals who flee a province in violation of a bail condition requiring them to remain in that jurisdiction create special concerns for law enforcement and the entire criminal justice system. Their flight delays and in some cases defeats the course of justice. The current response to this behaviour is the generic offence of failure to comply with the condition of release as enumerated under Section 145, Sub 3 of the Criminal Code. However, this charge does not differentiate between these bail violations and other bail violations, such as a simple breach of curfew. In order to create a transparent criminal record and emphasize the aggravated nature of this type of bail violation, we propose to create a specific offence of failing to remain in the jurisdiction in order to do so. Mr. Speaker, the creation of this offence is about one part of the response required to the broader issue of enforcing so-called non-returnable warrants. It is not intended to solve the very real challenge of returning the accused persons to face trial if they are arrested in some distance from where the alleged offences occurred. The challenge of distance is a practical one and is faced within large jurisdictions as well as within a single province. It comes down to the cost of moving people to where they need to be to stand trial for what they are accused of doing. This is an issue that must be addressed by the provinces under their responsibility for the administration of justice. Mr. Speaker, our government is working with our provincial and territorial counterparts to develop practical solutions to address the broader issue of returning accused persons to jurisdictions where warrants have been issued against them. In the meantime, Mr. Speaker, the creation of this new offence is a step in the right direction. The proposal for the creation of this offence is the result of extensive discussions among federal, provincial, and territorial officials led by British Columbia. The proposal was discussed and endorsed by the federal, provincial, and territorial ministers responsible for justice and public safety at their meeting in September of 2008. The broader issue of non-returnable warrants is complex, and a comprehensive solution will likely entail the allocation of significant resources and the development of best practices by provinces rather than further legislative amendments. Mr. Speaker, federal, provincial, and territorial officials are examining best practices to maximize the efficient use of available resources. Federal officials will continue to work with their provincial and territorial counterparts to identify long-term solutions to this very serious problem.